How many of you know what an irrevocable life insurance trust is? Okay. If I have a life insurance policy, let's say I have a $5 million life insurance policy, which I own, and I name my wife as the beneficiary. And I die and she gets $5 million. Well, there's no tax on that because she's a U.S. citizen, and transfers between U.S. citizen spouses are exempt from estate taxes. But now her estate is $5 million larger than it was the moment before my death, which means there's going to be there's a possibility of an estate tax at the second spouse's death. So what we would do is we would put this life insurance policy into an irrevocable life insurance trust. And let's take a simple example. We set up a trust. Trustee goes out, goes and buys a life insurance policy on my life. I've never owned that policy. I have no what they call incidents of ownership over that policy. The trust owns the policy. At my death, the trustee collects the death benefit. It's in trust for my wife's lifetime, and at her death, it goes to my kids. Well, it's not included in my estate because I didn't own that policy. And it's not included in my wife's estate because she's just a trust beneficiary. So that entire amount passes tax-free to the kids under an irrevocable life insurance trust. And we do a lot of those, okay? But some people have said, well, now that we've got this increased exemption and then we got the dissouye, we don't need an irrevocable life insurance trust. And I suppose to some extent that's true. Unless you're worried that the dissouye is going to go away, or you're worried that spouse is going to remarry and lose the dissouye, or you live in New Jersey. Because New Jersey has a $675,000 exemption. And New Jersey's tax law, estate tax law, is the 2001 estate tax law. So what that means is, if I have this life insurance policy and I leave it to my wife, and let's say that's the totality of the estate, she's got a $5 million estate. And she doesn't need a dissouye, she's got a $5 million exemption, no problem. But that $5 million is now subject to estate taxes at the wife's death. And as we saw before, that $5 million estate at the wife's death is just shy of $4 million in New Jersey estate taxes. So, does it pay to do an irrevocable life insurance trust? Absolutely does. So these things still have vitality. Rebalancing of assets. When we do estate planning, up until 2011, one of the things that we always wanted to do was to try and keep the estates roughly equal and to make sure that each spouse had enough in their estate to utilize their estate tax exemption. Let's say in 2009, the husband has a $7 million estate and the wife has $0 in her estate, and the wife dies. What happens to her $3.5 million estate tax exemption? Bye-bye, wasted. No trust is established. The husband now has a $7 million estate with a $3.5 million credit. Comes to us and we say, well, this is easy. This is what you're going to do. We're going to move $3.5 million over to your wife's estate. She's got $3.5 million. You've got $3.5 million. Doesn't matter who dies first. The trust will be established on the first spouse's death. We ensure the use of both estate tax exemptions. But with portability, the benefit of having at least an amount equal to the exemption in each spouse's estate is less important. Since GST exemption is not portable, it may still be necessary, though, if you want to take advantage of the GST exemption. Here's something that I think a lot of people, a lot of estate attorneys miss. When you retitle assets, how many of you do matrimonial law, family law? All right. What happens if I have an asset that I've inherited from my parents? It's in my name, it's always been in my name, I've never put it in a joint name. I sit down with a trust and estates attorney and he says, oh, we got to move this over to your wife's name. We're going to move it over to her name to rebalance the estate, all right? They leave your office 5 years later, you get a call, we're getting divorced. What happened to that $5 million? If they had gotten divorced before that transfer, it would have been an exempt asset. But now it's been moved over to the wife's name. Now, you might be able to make some creative arguments, but good luck with that. Now we have to rethink whether we want to retitle, and I think we ought to put more emphasis on what are the implications of doing that.